Hello and welcome to our Navigational Talk, the podcast for the maritime industry and for seafarers. So our topic today is a good weather period. The question often arises, what is a good weather period and from where to where does it count? Which part of the voyage can be considered as a non-good weather period and will be not counted? So therefore, the charter party have to be read, and in the charter party we will find the good weather condition. So either Beaufort 4 and maximum of Douglas Sea Scale 3 or Beaufort 6 and Douglas Sea Scale 4. That depends on the wordings and on the clause in the charter party. So which means the Beaufort 4 has a maximum wind speed, and this is a maximum limit. Everything which is beyond this limit is actually a non-good weather period. So which means if you are facing Beaufort 4, or you have, for example, more than the Douglas Scale 3, which is 1.25 meters, at the wave height you got in 2 meters or whatsoever, and also a swell is defined and is higher than in the charter party given, then this is beyond this, and these periods will be not counted. So this is actually clear. But good weather periods from where to where? So first of all, a good weather period will be counted all over the time charter. So which means every voyage have to be checked if it is part of the charter party. That said, the good weather clause is counting all over the time charter from the very first beginning to the very last end. So it is very interesting when we have a dispute and dealing with underperformance, like in the Polaris Shipping Co. Ltd. and Sinno Regis Enterprise & Co., the Ocean Virgo, because here the admissibility of good weather periods were in the charter party had no express limits on the length of the periods that could be admissible. So that's the first what we have to check. Is there any length when the good weather condition will be counted? Is it more than 24 hours? Is it means noon to noon, or is it between 15 and 18 hours? So this limit actually should be included. So to make it very clear. So to the fact, the bulk carrier Ocean Virgo was fixed for the time charter trip in December 2013, and the charter party was the NYPE, the New York Producer Exchange Firm. The charter party contained a performance warranty on the basis of good weather, smooth sea up to maximum Beaufort 4 and the Douglas Sea State 3, no adverse current, no negative influences of swell. Meaning, here clearly the limits are Beaufort 4 and Douglas Sea Scale 3. So what is not actually taken into account is adverse current and negative influence of swell. Under the charter party vessel performed a ballast voyage from China to Canada and then a loading voyage carrying coal from South Korea, where she was redelivered. The charterer claimed about $263,000 for breach of the performance warranties, relying on information gathered in the weather routing reports. The definition of good weather was not disputed, but owners defended the claim on the basis that the good weather period were too short to establish a breach of the warranties. But actually also the charter party does not really define what is the weather period which can be considered as a good weather. That means a period. So the arbitrator dismissed the charterer's claim, finding there were no admissible periods for good weather on which the vessel performance could be assessed. The arbitrator noted that in order for a period of the voyage to be admissible, that must be at least 24 hours, consecutive hours here, from noon to noon. So based on this interpretation, the arbitrator found that there had not been any periods of good weather. So the arbitrator discounted 2 periods where we have 14 and 18 hours, but respectively to his version that we need 24 hours in length, it will be not counted. So the charterer get this right to go to the appeal court, and at the appeal court, it's a commercial court, allowed the charterer appeal under the paragraph 69 of the Arbitration Act on the basis that the arbitrator had erred in law when he had limited admissible good weather periods to 24 consecutive running hours from noon to noon. So here the court held was not reason for the arbitrator to do this. The charter party did not expressly set that there are limits for admissible good weather periods. In this way, since there were no words in the charter party which really justified the construing of a good weather, like meaning good weather days of 24 hours from noon to noon, or 24-hour consecutive, or 24 consecutive hours. The court remitted the award to the arbitrator to reconsider where 14, 16 hours periods of good weather were sufficient samples on which to judge the vessel's performance. So here, actually, we can see that a good weather clause, which is part of the charter party, should also include the wording and where it is clearly marked what is a period, when is that when we can count this. Further, the good weather clause should always include that there are periods where, in the time charter, for example, the charterer will order suddenly the ship to go on slow steaming. But slow steaming will actually have later on a speed and consumption claim, because I cannot fulfill my speed, my average speed, which is given in the charter party. So therefore, it has to be read that under the good weather clause, if the charterer decided to have a low steaming, this has to be excluded from the speed and consumption again, and this has to be excluded because in the good weather clause, if I have good weather clause in, then I have a reduced speed. So which means if he wants to have slow steaming, then the average speed of slow steaming must be the basis of his calculation. So that have to be clearly marked in the very first beginning, what is actually the speed required, and if the charterer wants to go from the very first beginning unto the last end to slow steaming. Because in the voyage charter party, we have this clause just in time arrival, meaning in a voyage charter party, the ship owner will decide when the ship will arrive and gives this ETA. But actually, if the charterer now said, oh, dear Mr. Ship Owner, can you please arrive at this and this date and at this and this time, then the owner have to maybe to reduce the speed to be in time there. If he do so, he would actually breach the contract because the average speed, but with a warranty in the charter party, is not then fulfilled. Therefore, here, clearly, as soon as we have in a voyage charter just in time arrival, the speed and consumption claim will be no longer counted. So in the good weather clause, it is worth nothing in this judgment of the judge. It was Mr. Thier, did not consider it as an error in law in determining that the period of good weather was inadmissible because it was too short to be suitable sample. In fact, this was a permissible approach for the arbitrator to take in assessing evidence. The error of law was in excluding periods purely in the basis that they were not 24 consecutive hours running from noon to noon, because there was nothing in the charter party to support such restriction. As such, if the clause has been worded in another way, the case could have been decided differently. So, if we have therefore a period of 14 and 16 hours in question in this case of the Ocean Virgo, for example, we are considering as a sufficient sample in which to assess the voyage. The arbitrator will then need to determine whether those periods establish a breach of the performance warranties. If so, that level of underperformance will be applied to the whole of the charter party, meaning the good weather clause and this performance warranty are very close together. So which means if the 14 hours is in question and can be considered now as a good weather period, now we have to check, do we have an underperformance or do we have a speed claim? Whether there's any rationale in continuing the traditional noon-to-noon methodology is perhaps less clear, particularly when more detailed weather breakdowns are so readily available. So there is also an added complication in that a noon-to-noon approach will often result in either 20 or 25 hours because of the time zones the ship is passing. The case is also a good illustration to see that the Arbitration Act appeals procedure available under the certain paragraph for the Arbitration Act, that the judgment that the court should read an arbitrator award in a reasonable and commercial way, expecting, as is usually the case, that there will be no substantial fault that can be found with it and not with the objective of upsetting or frustrating the process of arbitration. So meaning the good weather clause have to be clearly defined. First of all, what that is a good weather clause and when is it counting? Meaning what is a good weather clause in regards to the performance the standards given as a warranty in the charter party, and when we are completely out of this performance standard, therefore the good weather clause cannot act. Like, for example, if suddenly the charterer likes to decide to make slow steaming. So which will be then an underperformance for us in the speed. And if we have to increase again the speed to reach it, the ETA in the next port, then we have a more consumption, which means then also a breach of this contract, which is given for consumption and also for the speed allowance. So here for good weather have to be clearly defined, and it is a good practice that if this in the charter party, that the ship owner and the charterer will decide what is a good weather period. That means, is it 24 consecutive hours or is it from noon to noon? And to make it clear so that there will be later on no disputes. Okay, I hope this case brought you a little bit more closer to this part with regards to good weather periods, and also with the breaching of a contract with regards to speed and consumption warranties. Okay, see you in the next broadcast.